Well,
Okay.
it's been 28.
Wow, good for you.
Well, good afternoon, everyone. If we could have you work your way back down, we will go ahead and get started. We're running a little bit behind. Some of our friends here on stage have some obligations, so we will try to end this right on time at around 4:45. But once again, want to welcome you all and welcome any members of the public who are here. This is part of the State Bar of Montana's 2024 annual meeting, and my name is John Mudd. I have the privilege to serve as the executive director of the State Bar and have for about the last 7 years. This year, the State Bar of Montana celebrates 50 years of the unified bar in Montana. And the actual roots of the State Bar go back to 1885, before Montana was a state. And a group of lawyers got together in Helena on a January evening and decided that they wanted to form an organization to be involved with the development of the law and the legal profession. In 1974, the Montana Supreme Court created a unified bar. The majority of states in the United States have a unified bar structure. And what that means is the lawyers of this state, for those of you who aren't lawyers, are all members of the state bar. And the court did that to better protect the public, to encourage higher standards of learning and integrity among the profession. And what that also does is it means that all the lawyers in this state are part of an organization to which they pay dues and assessments that helps the Supreme Court regulate the profession of law. Lawyers are officers of the court and ultimately under the jurisdiction of the court. But lawyers are often called upon, as we've heard in our other presentations today, to challenge government action, sometimes the actions of the legislative branch or the executive branch. And that unified bar structure is designed to provide the lawyers some independence. So although ultimately they are regulated by the Supreme Court, they are not dependent upon the legislative branch or the executive branch for their right to practice. Because often, again, they are called upon to challenge those branches. So it's sort of a libertarian notion, and there is no state money that goes into funding the operations of the bar. The lawyers of this state fund that themselves. They have a disciplinary structure. But all of that ultimately rolls up under the court. So it's very important to all of us who are lawyers who sits on the Supreme Court, not only because it affects our cases and our clients, but also ultimately the court is involved with the regulation of the profession of law. So I wanted to give you that background. Obviously, the lawyers in the room know about that, but there's members of the public here who may not. And we wanted to explain that to you today. I am joined on stage by 4 people who have all spent parts of their life in public service. And they have decided that they would like to spend more of their life in serving the public on the Montana Supreme Court. And I'm going to allow them to introduce themselves and tell you a little bit to begin here with about how what they want to do, what they've done, what they'd like to do, and why they think this is the right next step for each of them. And then we'll get into some more substantive conversations. But I'm going to start with you, Judge Bittigary, and we'll work our way down. And if you would introduce yourself, tell the crowd a little bit about who you are and why you're seeking a seat as Associate Justice on the Montana Supreme Court.
Thank you. Thank you for this opportunity to introduce myself, I guess, to all of you who are out there. I'm running for seat number 3, which is currently held by Dirk Sandifer. I was born in Sydney, Montana, where I still live, to courageous Basque parents who journeyed to Eastern Montana from the southwestern part of France, the Pyrenees Mountains, to escape World War II poverty. These parents in Montana were farmers raising small grains and hay, and then were ranchers raising first sheep and then cattle, having raised sheep in their native country of France. And they were mentors raising children, 6 of us, which was really beneficial to them because, as many of you may know, the profit margin in farming is really slim, and having free labor helps improve that. My dad's motto was, "Don't be a sheep." And from that motto, I learned not to be beholden to anybody, not to follow blindly, and to think for myself. It's a motto that I have followed throughout my life. I graduated from Culbertson High School and earned 2 undergrad and a law degree right here at the University of Montana, which I hold near and dear to my heart. And then had my first job at the state auditor's office in Helena, protecting Montana consumers against insurance fraud and securities fraud. During my second year of law school, my dad died unexpectedly, and the federal government took the position that his death was a default on our loan, even though we had never missed a payment, and even though my mother was a co-owner of the land and a co-signer on the loan. I had to leave law school for a bit and came back to help my mother fight the federal government on the position that they took. And once I pointed out to them that had it been my mother who had dropped dead instead of my father, and that it seemed like they were engaging in some sort of a discriminatory practice, they dropped it, stopped questioning the loan, allowed us to continue make the payments, and we own the land yet today. When I finished my law degree, I made a commitment that I was going to use whatever talents I had and my education to protect rights and fight inequity. After I'd spent 4 years at the state auditor's office in my first legal job, my family faced a dilemma. Either we needed to sell that farm because the free labor that had been there were all now in college and had left, or my then husband and I needed to move back to run it. So we moved back. For the next 14 years, I engaged in the general practice of law in Eastern Montana and Western North Dakota, handling all kinds of cases, representing mostly hardworking Montanans. During that time, I handled civil cases of all types, representing plaintiffs and defendants. I handled criminal cases, at times being the fill-in prosecutor at the local county attorney's office when they were looking for a replacement, and at other times being a public defender and handling cases on both sides. For the last 21 years, I have served as a district court judge for the Montana 7th Judicial District, which is a 5-county district in eastern Montana. In that time, I've handled cases primarily in eastern Montana, but in about 40 of the 56 counties across Montana, because when a colleague of mine would be either disqualified or recuse himself or herself from a case and was looking for another judge to take, typically a thorny case, I always accepted the challenge and took the cases. That experience has provided me the opportunity to know that some things just stay the same, but then sometimes there are differences across the state across this vast state. In 2006, based upon really what I had learned from my farming and ranching background, that you learn to work hard in that kind of an upbringing, but you also learn that you have to work smart. I started the first treatment court east of Billings, which has continued to operate to this day for the last 18 years, in which I've presided over. And the effect of that has been to reduce taxpayer expense, reduce crime, and transform lives. The reason I'm running for the Supreme Court is that we are experiencing unprecedented attacks on the judiciary, on individual rights, and on the rule of law, all of which are key to a healthy democracy. We need people on the Supreme Court who have a strong backbone, who are not prone to pressure from political parties or partisan efforts, or even their own personal views, and who can assess the issues that come before the Supreme Court fairly and impartially without any undue pressure from external forces. I have had a lot of time in the last 14 months to reflect on why I'm running for this court, and why democracy matters to me so much, and why I'm so grateful to live in a state that has a beautiful constitution like the one that we have. Our 1972 Montana Constitution is the envy of many other states. And it is so because it includes so many rights that are afforded to each of us as Montanans, not the least of which are the right to privacy, the right to access to public lands and waters, the right to the opportunity for an equal education, and the right to a clean and healthful environment, the right to know, and the right to participate in government. Also in that Constitution, like in the United States Constitution, is a requirement that we have separation of powers into 3 distinct branches, each with its own role. And at this time, when we are facing the kind of criticism, the kind of attacks that we're having, it's a threat to what the separation of powers was intended to protect. These 3 branches of government with the distinct roles, I'm going to focus just on the judiciary mainly. Of course, the role of the judiciary is to interpret laws and to handle appeals of cases that come from the district court and applications for writs. But the purpose of the separation of powers, as we all know from the civics classes we would have taken probably since we were in the 7th grade, is to prevent an abuse of power by any one branch and having one branch become too powerful. During the current environment, when we have 2 branches of government controlled by one group, and there are efforts to have the Supreme Court controlled by those 2 other branches of government, it is especially critical that we have strong-minded people who are thinkers and who are not prone to pressure. So the reflection that I've had is that one of the reasons really that is so important to me as a Montanan is that my parents grew up in occupied France during World War II. My mom was 9, my dad was 11 when that war started. And they had to quarter soldiers. They had to live through all kinds of things where everything were taken away from them. They developed a deep appreciation for democracy and a love for the United States, because though my dad died young, my mom lived until she was 91, and she died on January 6, 2022, 1 year after she watched what happened on January 6, 2021. That year in November for Veterans Day, she wrote something that I found after she died in the pocket of her lift chair that was a tribute to the United States soldiers that lost their lives, thousands of them. And to think that at the age of 91, that was the thing that was still uppermost in her mind, helped me understand why, in the environment in which I grew up, it's really important to me that we keep democracy alive in Montana. So I'm running for the Montana Supreme Court because I believe in our democracy, and I want to do my part to maintain it for us and our future generations.
Thank you, Judge Whittaker. I'm going to turn to you, Corey, and if you have a little bit on your background and a little bit of why you're seeking this position, running for the Chief Justice position.
All right, happy to do that. Thanks, by the way, John, and for the State Bar for this invitation to do this event. I've been to the Wilma multiple times. I've never been up on stage. We might do a little Hamlet afterwards if you guys want to participate in that. But thank you all for coming. I'm Corey Swanson. I'm the Broadwater County Attorney in Townsend. I'm in my 10th year as a county attorney. And if you know anything about county attorneys, about 90% of what I do is criminal law, and then I do civil law, and I have a deputy who's very able, who I give all the civil work to do. She's here somewhere, and I'm very, very grateful for her work, so I can focus on what I do. But my background prior to that, I worked for Tim Fox when he was Attorney General for a couple of years. I was in private practice for a couple of years before that, and I've done about 100 years in the National Guard. Just kidding. Seems like it. It's been about 27 years. But that combination of experiences has led me to decide that I wanted to run for the Supreme Court. And I'm doing it not because I, had this lifelong ambition to be on the court. I did not. Not that I don't love my life. I love my life. Married with 2 children. We're in Townsend. Their children are in sports and 4-H, and we're involved in our church. And my wife is a speech therapist, and we love our life. Why I'm running is because I think that there are some very, very good things about what our judiciary is doing right now. My goal is to try to help it do some things better. I think there's been too much focus on the political cases and the political controversy in the Montana Supreme Court. And by that, I don't mean the members of the court. I mean the discussion, the campaign, everything that's been happening publicly in the last couple of years. Let's not forget the vast majority of the cases that the Supreme Court deals with are not political. They're not in the news. There aren't protesters with signs out front. There aren't legislative hearings that deal with them. They are cases that are just your garden variety everybody else, all of you represent clients and you deal with every aspect of the law. And the Supreme Court owes its very best work, its very best understanding of the record, its very best legal opinions for a case that never gets a headline in the newspaper. But for those people involved in that case, it's the most important case in the state of Montana. They have years of their lives and they have thousands of dollars invested in that outcome. The court should be following the methodology that we learned from Larry Howell right here at the University of Montana Law School. So my campaign theme is no politics, just the law. It could also be, what would Larry do? It's good old-fashioned appellate judging. Now, that means you're focused on the legal record or the factual record from the district court. The court owes that factual record the deference to the standard of clearly erroneous. And it's reviewing the law de novo and providing the very best, very clearest, hopefully narrow holding to resolve that dispute and to then write a very clear opinion that provides stable and clear and reliable and predictable precedent that then we all rely upon as attorneys. That's what we want the court to do. We all know that. We all agree with that. My point is, if the court does that methodology on the non-controversial case that nobody ever hears about, that's not in the news, that the legislature doesn't care about, we simply apply the same methodology to the most contentious, the most political, the most controversial, the highest profile cases. The methodology should not change. And what's the answer? Is take politics out of the equation. So there's been talk about pressure and the legislature and all that. Shut your ears to it. Focus on just good judging and issuing that opinion that will stand on its own and that will have a precedental value that endures. That's what I want to do. I am not in this job or running for this job because I'm all motivated and fired up about the political issues. Now, certainly there's been a lot of that discussion in the campaign. People are trying to say that I'm the Republican scapegoat or whatever it would be. Here's what I am. I'm a guy who's been practicing law, who's been writing briefs, who's been arguing motions, who's been having jury trials, and who says, you know, the court most of the time does a darn good job. But occasionally I see the court abandoning the fundamentals or straying, I shouldn't say abandoning, straying from the fundamentals of good appellate judging. But Larry Howell would say, you guys went a little bit too far beyond the holding and I've got about 2 pages of dicta here. And on a cumulative basis, what that causes for all of us is it causes a lack of stability in the law. It causes an increase of uncertainty. It causes an increase in risks for our clients. And I think the court's done some amazing things. Maybe we'll talk about the efficiencies that Chief Justice McGrath has done, that we all owe him a great debt of gratitude for the work he's done as Chief Justice. For now we get very timely opinions, but I think that we can do better. And that shouldn't be a radical thought. If you take any group of 3 or more people of any type in any organization on earth, you have a team. And every team does well when it has a unity of purpose to accomplish something that's greater than themselves individually. And the way you get better is you look for mistakes and you find the mistakes and you embrace those mistakes. You understand those mistakes and you learn from those mistakes. And then you say, we're going to get better. As a lawyer, that's what we do, hopefully. And as the court, I think the court's done some very good things and continues to do good things. So the things I talk about are maybe the criticism or how we can get better. It doesn't apply universally. It probably only applies to 1 out of 5 cases. But I think those 1 out of 5 cases have become a tail that's wagging the dog when we come to this conversation. So I think there is a much brighter future ahead for the court. I'm a relentlessly optimistic person. All the conflict that's happening in our country and the conflict that's happening in our state and the fighting between the legislature and I guess the legislature trying to fight against judiciary, a lot of that's just noise. The best thing we can do as members of the court is ignore it and just do our job. And if there comes a big fight over legislative subpoenas or whatever, okay, well, let's sit down let's wisely look at the law. Let's wisely look at the facts. Let's make the correct decision. And if the correct decision is telling the legislature, you're on our turf, don't interfere, don't intrude, I will happily tell the legislature that. My life and my career and what I've done, I've not been a person that just rolls over and surrenders when I think that the other side is wrong. I'll say, sorry, legislature, you're in my arena. Don't tell me how to decide my cases. But I think you also have to have some ability to have mutual respect with a co-equal branch. In the international law, we call that comity, C-O-M-I-T-Y, and it means mutual respect among equals. The legislature and the judiciary are co-equal branches. And I may not agree with everything that some of the legislative leaders have said. In fact, a lot of it I don't agree with. But I want to listen to them. I want to understand their concerns. And I want to say, well, let me explain to you how the court actually works. And let me then zealously execute my duties and you execute your duties. But again, that should not be the centerpiece of any campaign because we're talking about a small minority of cases. The vast majority of the cases are people just want very clear and stable precedent when it comes to contracts and wills and roads and liability issues and attorney's fees and all the things that we deal with on a daily basis. That's where I'm going to spend at least 90% of my effort, as well as the leadership attributes or duties that the Supreme Court Chief Justice has to undertake. I think if we do that, that other 10% is going to work itself out. So thank you all for being here. And I don't know if how long this is going to go, but afterwards, I'm happy to stick around and visit with anyone that wants to visit. And I'm going to turn it back over to you, John.
Thanks, Corey. Judge Wilson, I'm going to turn it to you and give you an opportunity to tell everybody here a little bit about your background and why you're running.
All right. Thank you, John. Thank you, State Bar. My family roots are in the High Line here in Montana. My great granddad homesteaded in 1913. My folks both grew up in Malta. I was born in Billings. And when I was a kid, my dad embarked on a career of research and scholarship that took the family around the country. I came back and returned to Montana after law school in 1993 and began practice as a prosecutor first in Great Falls and then in Chinook and Kalispell, where I met my wife and we were married, and we've now been married 28 years. Our daughter just graduated from the U of M here this past spring and is now in Nashville studying. And I would say focusing on the audience of law students here, that if I were to trace my steps back from where I am now to where you are now, what happened for me that was a pivotal event in law school is that I fell in love with the law. I think we all go to law school hoping that ultimately we'll be inspired by what we encounter there. And I was challenged by really capable and caring professors, some of whom were judges who were professors on an adjunct basis. And so when I got out into the world of legal practice, I felt like I had been inspired appropriately, that I was revved up and ready to go. And by the time I finished my first year in practice, I had fallen in love with the courtroom. Eventually, I left prosecution. I opened a civil practice. I practiced all kinds of law. I did litigation. I kept my foot in the criminal arena by practicing criminal defense, mostly in federal court. Found that extraordinarily challenging. And what I discovered about being in the courtroom versus being in my office was that I'd much rather be in the courtroom where the phones wouldn't ring, where in fact Judge Malloy was happy to hold anyone in contempt who allowed their phone to ring. And we dealt with the practice of law in real time. And that to me was just inspiring. I think all of us who attended law school at one point imagined someday we may be on the bench. And for me, that journey was one that I only undertook when I had decided that I believed I was ready. And I didn't know what it was going to look like when I felt I was ready to run for judge or do the work of a judge. But it dawned on me about close to 20 years into practice that being able to look at a case, not only from the perspective of my client, but from the opponent, understanding where the strengths and weaknesses were in the evidence that was available, the strengths and weaknesses as to each party's theory under the law. And when I came to the point where I realized my client probably was going to end up on the losing end of things, and I'd rather be arguing the other side of the case, I thought, I think I've achieved that level of objectivity in my approach to the law that suggests I'm ready for the bench. And so it wasn't long after that, there was an opening in the district court. I've been a district court judge since 2017. And what has inspired me to run for the Supreme Court is along the lines of the progression that I've just described. I think that our Supreme Court needs the perspective of district court judges and those who can go to a cold record or a transcript, read it, and have some sense of the meaning it imparts and what truly happened in all likelihood in the courtroom. And I think it's the unique perspective of a district court judge that can bring that ability to someone who serving on an appellate court. I'll tell you the other thing that has been concerning me, and perhaps me personally, more than anything else, is that we have become accustomed to reading news reports about cases decided by courts at every level in every locale. And the first sentence, the lead line of every one of those stories, seems to say, this was the result in the case, this was the judge, and this is who the person was either appointed by or was supported by in getting a judgeship, as if that were the be all and end all of the explanation for the ruling in the case. And I think that is corrosive to our broad understanding, our notion of civics and engagement in our government by ordinary citizens, to put out those messages that you can understand all you need to know about a court's ruling in a case by the identity of the judge and possibly the sort of person or official who appointed or was responsible for putting that person on the bench. It's not the end of the story. And I think that we need to struggle against that tendency in our society. This campaign has been a wonderful opportunity for me to do that. Because in spite of all of the rhetoric that we hear, in spite of all of the frightening stories we're told about just how close we are in this country to some kind of constitutional crisis or Armageddon, I am an optimist. And as I've traveled Montana, I've been a lot of places. I've heard two things, actually three things that I think are important to report. Number one, Montanans really care about their Constitution. And second, Montanans truly care about their Supreme Court. And third, Montanans are not ready to give up on civil discourse. I think I've heard more than anything else while I've been out on the campaign trail, this sentiment, and it goes something like this. And it's usually by more experienced voters, shall we say. They'll say, you know, I remember a time in Montana where the legislators used to fight like cats and dogs during the day, and then they'd go out and have a beer and a sandwich at night. And they hearken back to those days. They're wistful for them. And I can tell you, I think we are only this far away at any given time in our history from returning to that level of civility. And all it takes is just a little bit of effort on everyone's part, but also a little bit of faith as well. I have faith still in Montana. I have faith in our system. I've watched with some dismay the level of divisive rhetoric that's being used inside and outside of the political realms. And I think that it is ultimately a passing thing, and that the best thing that a court can do, the Supreme Court in particular, is to maintain faith and hold faith with the compact that I think every individual judge enters into with the citizens of Montana when the judge takes the bench. And the first aspect of the compact is to remain neutral and not decide a case or announce or suggest what a ruling might be in a case before the case is fully heard, before it's briefed and argued to the court. And the second thing I think we need to do is try to avoid, so far as possible, either as candidates for the Supreme Court or as members of the Supreme Court, any sort of rhetoric that suggests that we are deciding the cases based on what we believe versus what the law says. One of the things that's taken an inordinate amount of time for me as a candidate is all these questionnaires I get from groups that are looking possibly to endorse a candidate. And when I get a questionnaire that says, do you believe so-and-so about the law? If I can answer the question by saying, this is the law as I understand it to be, I will. If there's not reasonably an ability to answer their question in the context or tenor it's asked, that just ask for my personal belief about the scope or extent of any constitutional provision, I don't answer it. And I think that in not engaging in that sort of rhetoric during this very critical time that we're all facing election is helpful both to Montana and its future, to the judiciary, and the faith that I think that people will hold in it as an institution, as long as we as candidates and as judges hold to our compact as well.
Thank you, Judge Wilson. Judge Lynch, you get the last on this particular part of our forum and the chance to tell everybody about yourself and why you're running. And then we're gonna, in the time we have, we'll delve into some more of a lightning round format. But Judge Lynch.
Thank you. Thank everyone for being here. I'm glad to hear that Mr. Swanson, Judge Wilson are optimists. I am a pragmatist. Our courts are under attack. Unprecedented attack, as Judge Bittigary mentioned. I'm going to get to my background in a moment, but I want all of you to understand this is a fight for our constitutional democracy. Make no mistake about it. You all read the newspaper. We have a Senate Select Committee that criticizes a judge for doing his job, that takes that judge to the Judicial Commission. We have politicians who are saying every Democratic judge should be impeached. Politicians that are friends of Mr. Swanson. I'm just being honest.
Who are they?
Jake Eaton, we'll get in that in a moment. But the point I want to make is this. Do not believe for a moment that you are not in a fight to save your rights. A right, Ramsey Clark, I read the other day, famously said, a right is not what someone gives you, it's what no one can take from you. So be prepared to fight to protect those rights. I was born and raised in Butte, a family of miners, 4 or 5 generations. Nobody looked too far up the family tree. My wife was a 30-year educator, also from Butte. I was fortunate enough to have a good education, as all these folks did. I graduated from Carroll College in biology and chemistry. I went on to Montana State University to get a master's degree in zoology and genetics. That experience taught me a true love of Montana and the pristine nature of Montana. Ultimately, I decided to go to law school with the blessing of my wife. And I was fortunate in the legal profession. I was able to work with one of our finest jurists, Paul Hatfield, for 14 years. A little bit unusual. I was law clerk for 14 years, but I will tell you what, there was no better experience that one could have to prepare them to be a judge and most certainly a chief justice. I was able to work with other fine judges, Jim Batten, William Murray, Rusty Smith. The point I'm making is that when I decided to run for the Supreme Court, I had a passion about defending the judiciary. I retired as a federal judge, but the nonsense and the attack on the judiciary is something I couldn't just sit idly by. I was reminded of Martin Luther King's statement, when he said, the day we stop speaking up about what we believe in is the first day we start to die. That's where I am. I will tell you this. I would not at all 20 years ago have thought I could be Chief Justice of the Montana Supreme Court, but it goes beyond that. You are the leader of the entire judiciary of the state of Montana. I would never have just stepped up one day and cut my teeth on wanting to be Chief Justice. As a matter of fact, as I sit here today with 38 years of legal experience, 14 years roughly of being a judge, and another 14 in the federal system, I am still conscious of the fact that it's a daunting task. And I don't go into it lightly. I have no criticism of our current court. Mr. Swanson mentioned Professor Howell. I didn't know Professor Howell, but there's one thing that can be said. Unless you have sat in the chair, unless you have written the opinion, unless you have had to make those decisions that affects people's life, talking about it is one thing, doing it is an entirely different matter. And the two judges on the stage with me will tell you that. It's not an easy task. The first day I went into court as a federal judge, United States magistrate judge, we start our discussion, all of a sudden there's an objection about something, and I was kind of looking around for where the heck is the judge. It's not don't think you walk into it without training. It is essential to have training and experience to run the Montana judicial system. I am prepared to do that. It's hard for me to stand here. It's hard for all of these folks to stand here and tell you how wonderful we are, but I will tell you this. These races are so important that we have to do that. We have to tell you who we are, what our experience is. I, as I said, worked as a law clerk, and then I was in private practice with my good friend Tom Boland. And I was one of those nefarious, I guess these days in the political realm, quote, trial attorney. Well, let me tell you, a trial attorney, according to Webster, is an attorney that prepares cases for trial. And I asked myself, I thought that's what I did. I wasn't some political creature, but I will tell you this. When there's these political attacks on, quote, trial attorneys, as Judge Wilson said, especially for the law students, they don't believe that. I am so proud of the years I spent as a trial attorney. Why? Because there's always someone bigger than you. There's always someone bigger than your business. And when you get in a fight with the bully, you need someone to protect you. That's what I did. I protected the Scobie School District from insurance companies. I protected Mountain West Bank from insurance companies. I was able to prosecute, and again, I don't want to blow my horn, the two largest class actions, I believe, in the state of Montana against two of the largest lending companies in the United States for predatory lending, resulted in $50 million coming into the state of Montana to save roughly 5,000 to 6,000 homeowners' homes in Montana. That's not something I'm ashamed of. And so when you hear this rhetoric about I'm a liberal trial attorney, I am a trial attorney, I was a trial attorney. More importantly, I'm proud of that, and I am also a judge. I've had to make the decisions, the hard decisions. You don't please everybody, but I will tell you this. I will work as hardest as I ever have to be the Chief Justice in Montana, because the judicial system has to remain independent. If the judicial system is not independent, that is not a constitutional democracy, which is what we are. Everybody has to remember that. And I want to say this, because there is such political rhetoric in the papers these days about the legislature of Montana versus judiciary Montana. I go back to many years ago when I read Alexis de Tocqueville, which I'm sure a lot of you have. Or if you haven't, you should. But the one thing that he said in his two-volume discussion of American democracy was, and I'm paraphrasing, the most marvelous device that was created by the United States Constitution was giving the courts of justice the ability to declare a statute unconstitutional. Number one power, because that is the number one barrier to a tyrannical legislative assembly. Now, I had a different tenor than these folks, but I tell you this. These elections are going to direct the future of this state. They are going to direct the future of our grandchildren, our families, and we can't take it lightly. It's one thing to say, I want to be a nice guy or a nice woman. I want to compromise with everybody, but there comes a time when you have to go toe to toe. I will do that for Montanans to protect their constitutional rights. Thank you.
Thank you, Judge Lynch. We are in a position, and I want to make sure that can the candidates up here stretch a little bit on time so we don't run completely out of time. One of the things I wanted to give everybody is a chance in this particular forum to explain to the lawyers here and the members of the public who you are and why you're running. I'll do a lightning round now, I guess, of a couple of questions because we're short on time. During the last legislative session, we've been talking about judicial review. There was a resolution introduced in the legislature, didn't ultimately pass, said Marbury versus Madison. Those of us in the bar understand is I think Justice Comey Barrett described it as super precedent in her confirmation hearing, was wrongly decided, and that judges and courts should not have the power to interpret the law. What do you think about Marbury as precedent? And I'm going to go to you first, Corey. And precedent, not precedent.
Oh, absolutely precedent. It's a foundation of how we understand our United States Constitution and really how we operate as lawyers. But I think it's clearly built into the structure of the Montana Constitution. So it's a fundamental duty of the judiciary, fundamental power, and I'm sure there's people that criticize it, but I don't think we can do our job without that authority to exercise judicial review of legislation. And John Marshall was very wise in laying that as a foundation at the beginning of our country.
Judge Bittigary?
I ditto.
Judge Walsh.
Well said, Judge Bittigary. Yeah, the judicial review is an authority that has been well established in Montana since our first constitution was adopted in 1889, and it has continued unabated throughout the years that we've been governed by our 1972 Constitution. So I do agree, judicial review is a power and authority that our Supreme Court has.
Well, I agree with Judge Wilson, but I want to make clear that it's just not judicial review. The courts are the final arbiter of the law. The Marbury versus Madison, as Mr. Swanson said, is the law of the land. We would not function, again, as a constitutional democracy without that rule. The Montana Supreme Court has acknowledged that the Supreme Court's authority to interpret statutes is plenary, meaning that's the end of the line. I'm glad to hear Mr. Swanson say that, because I was concerned when I saw a resolution, which is still on the books by the Montana legislature, that said Marbury versus Madison is nonsense, that the legislative branch has as much authority to declare what the law is as the courts. So I'm glad to hear that. I'm happy to hear that. I hope if you're elected, you abide by that. I'm concerned, but we'll talk about that later. The legislature of Montana does not believe in Marbury versus Madison. Make no mistake about it. That is why the judiciary is under constant attack, and it's actually a false attack. You all, I know, are very well versed, but when you pass unconstitutional laws simply to set up a fight so that you can go to the press and attack the judiciary, that's not healthy for our democracy. In any event, I agree with Marbury versus Madison. I agree with the Montana Supreme Court precedent. that the courts are the final arbiters. That has to be how our democracy works.
I'm just going to give Corey a chance to respond.
Appreciate it. I don't understand where Judge Lynch thinks that somehow I have this nefarious or radical view of the law. Nothing ever in my entire career as an attorney have I given indication that I have some radical view of the judiciary as a powerless institution. That's absolutely not the truth. I am fully invested and committed in the strength and the power and the health of the judiciary as an institution. There might be some people in the legislature that think this or think that, but I don't understand why you keep trying to attribute those views to me.
Oh, well,
Those are not my views. And
Okay.
you're not running against Austin Knutson, you're running against Corey Swanson.
I am running against Corey Swanson,
Yeah.
but let me be clear. Haver News, Mr. Corey Swanson, in the historic case of the legislative subpoena, where the entire Montana Supreme Court stood up in the McLaughlin case and said no. Mr. Swanson, I can quote you from the Haver Daily News that said the court had unclean hands. What you mean by that, you can explain to these folks.
I will.
I also want to bring up your comment in one of your fundraising letters where you said, I and you, we have the opportunity to reorient this leftist, liberal, activist court that has done nothing but harm to Montanans for over 2 decades. Number 3, you charged a crime that didn't exist. And well, I'm just telling you the facts. You charged a crime that didn't exist and a person was convicted. The court did its job in saying, we're sorry, Mr. Swanson, but this man is entitled to due process, notwithstanding the fact it was a sexual assault case. You go on the internet and you say, see what I told you, this liberal leftist activist court?
Judge Lynch.
Well, don't interrupt me, John, till I finish.
Well, I'm the moderator
Yeah,
here, so I'm going to interrupt
okay.
you with all due respect.
Anyway, to attack.
And we're going to
wrong.
let Mr. Swanson respond. And we have some other questions we'd like to get to.
So first of all, I said no one had clean hands. The court should not permit internal voting where judges are opining on the constitutionality of legislation when it's in the committee process. Shouldn't do it, period. The Attorney General made multiple unforced errors. The legislature did things wrong. The Department of Administration, everybody had, that's what I said. Nobody had clean hands. They all did things, unforced errors in 2021. The goal here is to move beyond that rather than relitigate that. Number 2, I have said all along that I think the court has over the years been favoring liberal outcomes, and I have a problem with that. It's not our job to favor liberal or conservative outcomes. It's our job to correctly interpret the law, follow the process, let that outcome be decided based on the journey of following the law and based on the foundation of the record of facts. There are too many times, and I don't want to go into all of them, and they're not all the time, I would say, but there are cases where I see the court getting to an outcome when the facts and the journey should have taken them into another place. Third, he's referring to where the court this year overturned a sexual assault conviction, saying that I charged a fictitious crime using sexual assault by a common scheme. Okay, there's an example of where, number 1, the court raised it sua sponte. It was never raised at the trial level. It was never raised by the appellate lawyers. Why? Because the court got it wrong. The court was relying on the current statute, not the statute that was in effect at the time the conduct happened and the time that the crime was charged. The court never took briefing on it. They never took oral argument on it. They got it wrong. How do I know it got it wrong? Justice McKinnon wrote that opinion. Justice McKinnon wrote an opinion affirming me charging someone with assault with a weapon by common scheme using the exact same statute at the same time frame in 2017. The court unanimously affirmed that charging agreement or charging document, said I charged it correctly from a 2017 charge. This year, they reversed a 2017 sexual assault using the same charging methodology. Well, guess what it's done? It's wreaking havoc statewide. There are criminal convictions all over the state based on that time era that are now subject to post-conviction relief. Why? Because the court didn't follow the process. The parties never raised it because it was never an issue. The court looked at 2024 statute rather than 2017 statute. That's activism. And by the way, they got it wrong. If we think we have an answer, let the parties brief it. That's going to lead to a more accurate outcome. That was my problem with that case, not because I lost. And by the way, that case is done. That gentleman came back and pled guilty, and that case has been sentenced.
Okay, we're going to run out of time here. I want to ask Judge Wilson, yesterday, the Law and Justice Interim Committee passed a committee bill purporting to reject, or will go to the session to reject, a number of Supreme Court rules. One of those rules was a change to the Uniform District Court rules, which created the informal domestic relations trial process. I know you wrote a letter in support of that during that rule change, and whether that rejection is going to be effective or not. I do think I wanted to ask the two trial court judges here, access to justice, the expense of folks trying to retain counsel, and in many of these domestic relations cases is really where we see that access to justice issue. If you're on the court has an access to justice commission. What are your views on what can be done to help more Montanans be able to access the courts in a more affordable way?
Was the question about my writing a letter in support of the informal domestic relations?
Just as that is an example of the kinds of processes.
Sure.
That's why I wanted to raise that.
Right, yeah. I served as chairman of WINGS, which was a committee that was to inform the legislature and suggest changes or improvements that can be made to guardianship law, but I didn't write, so far as I remember, any letter suggesting that this change in the domestic relations representation rule ought to occur. But that being said, access to justice is a very critical thing. And one of the things that I really appreciated hearing in the presentation just before ours by Bill Bay, I think is his name, he was talking about how we need as lawyers to sort of run interference, for lack of a better term, to protect our judiciary, to encourage or discourage people from criticizing it. And one of the things that I've observed an explosion in as a district court judge is the number of people who represent themselves. And everyone knows the old saying that an attorney who represents himself as a fool for a client. But we are telling people that you may represent yourself. We may be falsely encouraging them to think that they can competently represent themselves. And aside from all the merits and the difficulties that brings to a trial court, one thing that I know that attorneys provide of tremendous value to courts at all levels is a buffer between the client and the court, because it's impossible to render a decision to make everybody happy. When the litigants are self-represented, I can tell you it's much more often the case that they will never accept the ruling of the court. They will never believe that the judge wasn't biased or stupid or corrupt or all three. Lawyers who can talk to the client after the decision comes out and say, look, you know, we gave it our best shot, could have gone either way. I really felt good about it. We can possibly appeal. Just those few moments of consolation go so far in protecting the independence of the judiciary and also the public's faith in the judiciary as an institution. I would like to see, so far as access to justice is, the bar get active in appointing mediators before self-represented litigants go into court and get into the meat of their litigation. It's not overly difficult or time consuming for lawyers to involve themselves at that stage. In virtually every kind of case except criminal cases now, there's mandatory mediation before the case goes to trial in any event. And just those few hours or minutes that you spend talking with a self-represented litigant about how this is how the process works, there are likelihoods of success and failure. It's all up to the judge to decide the credibility of witnesses and so forth, can go a long way, not only to ensuring access to justice and perhaps conflict resolution before the case even goes much farther in litigation, but also will, I think, serve to protect and preserve the reputation of the judiciary as an institution and as an independent institution. So thank you for that. And I hope I didn't go on too
No,
long.
that's okay, Judge. I appreciate that answer. Judge Bidigary, thoughts on that?
Well, I don't know what your question was because you were looking.
Oh,
at
sorry.
it.
It's
There's a
hard to hear
fan
up here
here.
on stage, but
So just a short part of it.
just
Very good.
the importance or your observations on the importance of access to justice. Obviously, the court has an Access to Justice Commission. And what can the judiciary be doing to improve Montanans' access to the courts?
Well, we have the Montana Access to Justice, the Montana Justice Foundation, of which I am an ex officio member. And I sometimes do kind of struggle with some of the things that we're doing, all the online forms and everything that are available that people typically complete incorrectly. Where I live, there aren't very many attorneys. It's rural. Everything's far from one place to the other. We have, from the time that I first became an attorney 39 years ago, and now, I've seen a real change in an increase in the number of people who file cases pro se. And also, when I first was practicing law, we had a strong Montana Legal Services division that provided services throughout the state, including the part of the state where I live. We don't really have that anymore. We don't even have self-help programs where I live. And so basically what happens is that people fill out the paperwork. They're filled out incorrectly. I try to have all pro se people show up at the same time. I give them a little primer on this is how a case unfolds. These are the basic rules of evidence, whatever, so that they can do as much as they can themselves. But even before we get to that point, it's problematic because the paperwork is done all wrong. So I find myself doing many orders telling them this document is incorrect because you didn't fill out this or that. And so that we get the right information into the record. It's very, very time consuming for the judges. And the judges, of course, are not allowed to give legal advice. And it's a very labor intensive process. I wish what the judiciary can do, I don't know, we don't control the purse strings that would provide availability of even like paying some amount of money. I don't think it should fall completely on the shoulders of attorneys to have to bear the burden of the poverty of people that can't afford to hire a lawyer and pay the regular fee. I don't think I've never thought that was completely fair. I wish there were some way that we could at least give them something, but the judiciary doesn't control any of that. On my end and where I live, what we have done in my judicial district is that there are 2 judges in my judicial district, and we mediate for each other all the family law cases where the people are representing themselves. And so that is the way that we've at least the family law issues addressed. That and some of the other ones, some other civil cases too. We've been able to mediate for each other because they can't even afford a mediator. So I don't know. I don't know the answer to the question. It's complicated, and the judiciary doesn't hold all the power to be able to fix it. I mean, it's going to rely on other branches of government to assist.
One last question, and I'm going to ask you for a yes or no answer so that we can wrap up. There has been talk in recent years about trying to remove regulation of the profession of law from the judicial branch. Obviously, for the lawyers in the room, that's an issue of some concern and discussion. And I just, as the ultimate regulator, the Supreme Court of the legal profession in Montana under the Constitution, just wanted to get your views, yes or no. Should the regulation of the profession of law remain within the judicial branch? Judge Lynch.
Yes.
Judge Wilson.
I believe it would take a constitutional amendment to change the current state of things where the Supreme Court does.
Okay.
Yeah, so I agree with both those. Yes, it should. I think it would take constitutional amendment to change it. 15 years ago, I represented some people in other professions before the Department of Labor licensing boards, and I was not crazy about their due process. So people that want to do something different, first of all, I think that would be the wrong answer, and the court needs to keep it. But secondly, they shouldn't fall in love with some other model they think's working great that I'm not sure it's working great.
Judge Bidigary.
I think that the judicial branch should continue to operate as it has in attorney discipline.
Well, I want to thank everyone for being here. First of all, And again, we'll make clear that the State Bar of Montana is pleased to host this forum. We don't endorse any of these candidates. They're all members of the bar. And so we want to do this simply to be able to allow them to provide some perspective on who they are and why they think they ought to be on the Supreme Court and to answer some questions. I appreciate their willingness to extend a little longer since we got a little bit behind today. And thank them all for being here, and thank all of you for being here as part of our 50th anniversary of the State Bar of Montana. So thank you.
Thank you.
Thank you all.